Hi everyone, I hope that you are safe and doing well. In continuing my thread on contract law, today I will be looking at the element on acceptance. In other words, today I will be looking at what an offeree should do to enter into a legally enforceable contract. In observing the offeree's duties, I would explain this through the definition on acceptance. An acceptance is defined as an unqualified assent to the terms of the offer. This means the particular offeree should accept the offer as it is. You cannot accept the offer by imposing new terms or conditions. Neither can you bring outsiders into the contract. Now, when I say this, you might wonder that why is the offeree bound to accept the offer? And you might also have a feeling that there is no fair bargain between the parties. It's nothing like that. If you all had watched my previous audios, you all would realize that we discussed a concept called invitation to trade. In this invitation to trade, the offeree was also given an equal opportunity to accept the offer. That is, by engaging in negotiations. After bargain, when parties have decided their terms and conditions, subsequently only the offer is made. And that is that particular offer that the offeree is accepting right now. So there is no unfairness committed on the offeree. So moving forward, the offeree should satisfy 4 rules on acceptance. They are unqualified assent, on identical terms, communication, and the awareness of the offeree. In looking at the first rule on acceptance, it has the same wordings as the definition. That is unqualified assent. Here what we mean is that the offeree should not accept the offer subject to conditions. You have to accept the offer as it is. In other words, if the offeror has made an offer to you, the particular offeree, it's your duty to accept the offer as it is without bringing a third party into the situation. If you tell the offeror, yes, I am interested, but I have to get the consent or the approval from so and so. It may be your parent or your fiance or your spouse or even an expert. That doesn't qualify the first requirement. This is because the offer was not made to that stranger or the outsider. It was simply made to the offeree, and it is the offeree's intention that is important to the particular offeror. Moving on to the second rule says acceptance must be on identical terms. This, in other words, mean the offeree should mirror the acceptance to the terms of the offer. You have to accept the offer as it is without any terms or conditions imposed by you after the offer is made. In the event the offeree tries to alter the existing terms of the offer or introduce new terms, we call it a counter offer. A counter offer is explained in the case of Hyde versus Wrench. Now, in Hyde versus Wrench, we observe where the offer was made for £1,000 and the offeree has accepted the offer for £950. So the prices do not tally with one another. Therefore, it's a counter offer. When a counter offer is made, of course, the original offer is terminated. Moving on to the third rule, the third rule says that the offeree has to communicate the terms of the offer. This communication can be done either to the offeror or his agent. But the silence of the offeree would not amount to a valid acceptance. In Feldhaus versus Binley, the uncle had expressly told the nephew that if the nephew had decided to sell the horse to the uncle, and if the nephew is silent, uncle would treat the horse to be his. Now, when the matter went before the court, it was decided by the court that the silence of the nephew is an invalid acceptance. The reason being that there is no communication of the nephew's intention to the offeror who was his uncle. Finally, the offeree should be aware about the terms of the offer. When you are accepting the offer, you should know in and out about the offer. Then only you would be an entitled offeree who is entitled for a reward, or who will be able to bring an action against the offeror who may try to breach the contract. This we observe in the landmark Australian High Court case called R versus Clark. In this case, a particular person had given information to the police, but he was unaware that he is entitled for a reward in providing such information. Now I would summarize the entire content in acceptance. That is, acceptance is to be done only by an offeree, provided the offeree accepts the offer without bringing a third party, or without introducing new terms or altering the terms, and has to communicate the acceptance to the offeror with proper knowledge about the terms of the offer. So I hope that this particular audio is fruitful to you all. Have a good day.